When you need to build up your team to handle the growing chaos at work, use Indeed Sponsored Jobs. It gives your job post the boost it needs to be seen and helps reach people with the right skills, certifications, and more. Spend less time searching and more time actually interviewing candidates who check all your boxes. Listeners of this show will get a $75 sponsored job credit at Indeed.com/podcast. That's Indeed.com/podcast. Terms and conditions apply. Need a hiring hero? This is a job for Indeed Sponsored Jobs.
Welcome to the Monopoly Report. The Monopoly Report is dedicated to chronicling and analyzing the impact of antitrust and other regulations on the global advertising economy. I'm Alan Chapell. I'm a privacy and regulatory attorney and have worked with hundreds of digital media and ad tech companies over the years and taken over 40 of those companies to successful exits. I also publish a monthly regulatory outlook for digital media worldwide called the Chapell Regulatory Insider. You can find a link to a sample copy of the Chapell Regulatory Insider in the show notes. Today's episode focuses on data sharing in connection with Google's search business. As you probably know, Google has been adjudicated a monopolist in the U.S. in connection with Google's search business. The remedies in that case include a requirement that Google share certain search data with competitors. There's also a piece of legislation being floated called the Search Act, which, if passed, would require that Google share data as well. Google has also been deemed a gatekeeper under the EU's Digital Markets Act, which requires Google to share certain search data. And there's a similar initiative taking place in the UK, so you probably get the theme by now. In other words, Google's search business is now under pressure to share search data pursuant to competition law. But because nothing is ever easy when it comes to Google, the process of actually turning over this data to competitors is being complicated by privacy and data protection law. There are a bunch of tensions when it comes to the sharing of search data. Privacy versus competition, privacy versus security, personal data versus anonymization, whether consent is a workable legal basis at this scale, and whether privacy-enhancing technologies can thread the needle. My guest today is exactly the right person to help us untangle all this. Alissa Cooper is the executive director of the Knight Georgetown Institute. She is a recognized leader in the development of global internet standards, policy, and governance. Alissa has served in a variety of roles in the tech industry, including as chair of the Internet Engineering Task Force, the world's premier internet standards organization. She led the IETF through significant transitions related to internet security and encryption, network performance, privacy, and real-time voice and video. She previously served as the chair of the IANA Stewardship Coordination Group, which delivered the technical plan that allowed the U.S. Department of Commerce to transfer oversight of internet governance to the global multi-stakeholder community. Alissa and I first crossed paths when she was working at the Center for Democracy and Technology. I'll place Alissa's full bio in the show notes. It's rather impressive. And me? Well, I love poking at seams within the law. So this is a particularly fun subject for me because in my view, the set of issues raised here are such that just about all of the players, certainly Google and their competitors, but also regulators, policymakers, and even advocates are finding themselves in the uncomfortable position of making conflicting arguments depending on the venue they are in. I'd encourage you to listen for this phenomenon as we move through the discussion on this episode. So let's bring in Alissa Cooper from KGI to discuss data sharing in connection with Google's search business. Let's get to it. Hey, Alissa, thank you so much for coming on the pod. How are you?
I'm great. Thanks so much for having me.
Where are we finding you today?
I'm in Washington, D.C.
Good fun. Has it quite hit the August, Mumbai feel, or is it a nice day?
No, it's quite nice today. I was in Chicago this week. I just got back and I was expecting, the wall of humidity, but today it's pretty nice.
Fantastic. Yeah, I'm looking forward to getting out today. It's absolutely gorgeous in New York. And what a better day for a public policy discussion on a podcast.
Absolutely.
So, well, let me set the table with that as a poor beginning. So Google's search business is under pressure from at least four different directions right now. You've got, the DOJ antitrust case with the technical committee. You've got the UK CMA pushing for, data portability. You've got the EU Commission under the DMA. And then there's sort of a separate discussion around the DSA, for providing access to data to researchers. And it seems like every single one of those discussions is landing on the same question. Should Google have to share its search data? And if so, and I think the answer to that is yes, but if so, how? And it raises a whole bunch of different tensions. You've got privacy versus competition, privacy versus security, personal data versus anonymization, the effectiveness of consent as a legal basis, and whether, privacy enhancing technologies can even present a viable solution to any of these challenges. So let's start with the big picture. You frame mandatory data sharing as a competition catalyst, and you reach back to 1956. Those were the days, weren't they? Back in 1956, the AT&T consent decree, where you note that royalty-free patent licensing reportedly drove a 12% bump in innovation. So why is search query data analogous to transistors back then? And then where does the AT&T analogy break down?
Yeah, so I think it's useful to try to look into the history here. We don't have a ton of cases that we can draw from, but I think the comparison is an interesting one because at both of these points in history, at least the sense that we get from living in the world and looking at what's happening with technology is that we're at a sort of inflection point. And so if we go back to the 1956 consent decree with AT&T, we have a similar situation to what we have now. We have a monopolist who had an asset that they likely otherwise would not have been able to obtain absent, the dominant conduct that led to the proceeding in the first place. And in that case, the agreement with the court required them to sort of unleash that asset into the market in a way that allowed competitors the ability to innovate and to access innovation in a way that prior to had been sort of locked up by the dominant firm's advantages in the market. And so that pattern, that paradigm is, I could have said that exact same story about Google and the search data, that this data related to their user base is so valuable and that once they've been able to accrue that many users through the dominant conduct, they're the only ones who have access to this asset. So the comparison is to show that when we unleash that asset into the marketplace, then we find that competitors are able to make use of that asset in novel and interesting ways that the dominant firm maybe wouldn't have thought of.
And are there any places where that analogy sort of breaks down for you, or you feel like it's pretty strong? It sounds rather robust to me, but I'm curious. Do you see a place where it breaks down?
I mean, I think if you look at the specifics, of the two cases or of the consent decree with AT&T, the first one always to note with these sort of empirical studies is that patents don't equal innovation. So the statistics of a 12% bump in innovation relates to a quantitative assessment of what the patenting activity looked like. Back then, probably the number of patents maybe was a little bit closer of a proxy for the amount of innovation. But even so, it's not a perfect way to measure innovation, but it's just a thing that we can measure. It's one of the more concrete ways we can measure innovation. So that's just kind of one caveat about the analysis. And then the other one is that I think when we look at search data and the data that's at issue in these various different regulatory and court proceedings, search data is narrower than all of Bell Labs' patents, which is what the consent decree was about. So those patents covered a broad range of different kinds of technologies, and therefore the possibility was to unleash innovation in a wide variety of different sectors. And in fact, the paper that the statistic is drawn from shows that there was not really an increase in innovation in telecommunications specifically, but in all these other places where Bell Labs had been investing and innovating. And so when we look at this case, I think the asset at issue is just quite a bit narrower than it was in the AT&T case. Okay,
so we now have at least three different vehicles pushing Google to share data. And I mentioned this in the opening. You've got the commission under the DMA, you've got Judge Meda's remedy and US v. Google, and you've got the proposed US Search Act. But where do all these regimes converge and where do they meaningfully diverge in terms of what specifically Google must hand over?
Yeah, so each of these is actually building on and a bit broader than the prior one. So if we start with the DMA, the provision Article 611 of the DMA is specifically focused on this sort of user-side data set, this ranking, click, query, and view data, all data that relates to what the user inputs to the search engine, what they get back on the search engine results page on the SERP, and how they interact with those results that come back. So that's kind of the most limited one is the DMA provision, just applying to that, what's colloquially called click and query data. In the US v. Google remedy, it also has a user-side data sharing provision. It's a bit broader, I would say, than what's in the DMA in terms of the scope of the data, because the judge has basically keyed it off of a couple of models, a statistical model and a deep learning model that Google uses to operate its own search engine. And the order basically says all the user-side data that Google uses to refine those models has to be made available to competitors after the privacy protections have been put in place. So it's a bit broader than the user-side data sharing under the DMA. And then there's also a provision in the order requiring some of Google's index data, search index data of the web. So not user-side data, but the data that Google has gone out and crawled from the web in order to build its index. There's a provision requiring the sharing of the index data. And then when we look at the Search Act, it has user-side data, actually quite broadly defined. It has index access, also quite a bit more broadly defined than in the court remedy. And then it also includes ads-related data as well that it would require Google to share. So each of them kind of builds on the previous one and broadens out as we go from the DMA provision all the way through to the proposed legislation.
Was there a sense that previous iterations maybe didn't go far enough in your view? Or is it just the more somebody dives into something, the more specific the appreciation of it gets?
Well, I think the thing is that these different sort of regulatory tools, for lack of a better word, are in a way meant to serve different purposes. So in the DMA, the provision in 611 is really one of the only provisions that is trying to address the competitive landscape in search specifically. And broadly speaking, what I would say about the DMA is that it's attempting to increase contestability and fairness in the market as opposed to competition for the market. So if what you were trying to do was really in a full-throated way stimulate entry in search, you would want a bunch of other provisions that haven't been included in the DMA. Like data sharing isn't going to get you there on its own, most likely. So the objective of the remedy is meant to remediate the illegal monopoly conduct in the U.S. case, and so it has a broader remit to it. And then I think the legislation is in some ways a reaction to what you did and didn't get in the remedy, right? It's a common thing that happens. People propose legislation after they've seen the remedy. They see where all the gaps are, the items that didn't quite make it into the remedy, and they're also anticipating a lot of, appeal activity around the remedy, which is already underway, and trying to fill in those gaps. So I think it's like a natural thing that we, isn't unexpected.
So I'm less familiar with the Search Act, and I'm curious, does that touch on AI overviews or the AI component? Because it seemed like the DMA did. Judge Mehta seemed like he went out of his way to avoid touching AI, maybe because it was new. I don't really know. But does the Search Act try to address what arguably Judge Mehta refused to address in the remedies when it comes to AI?
I think if you look at the Search Act, and I wasn't involved in its drafting or anything, I just, a person reading it on the internet. In general, the definitions in the Search Act are concise, and therefore they are quite broad. Like they don't give a lot of detail specifically about what is or is not in scope. They just sort of kind of define user-side data broadly as like all the data that the browser sends and receives when a user does a search. So I think there would be, since it's, a very new proposal, there will be a lot of wrangling back and forth around what does that actually mean and what's the actual scope. So yeah, I think if you just, read it in black and white today, it looks quite expansive as if it would cover the AI features on the SERP. But, the devil's in the details. And I think people will argue about that if it starts to look like that legislation is moving forward.
So similarly in the EU, they focus on this concept called a parity principle, where rivals are supposed to get access on par with Google, and they're a little bit more prescriptive, specifying daily sharing. And it seems like the U.S. judgment is a little bit more high level and less prescriptive. And I'm curious, you've been following the back and forth with the technical committee in the DOJ case. And do you think they're going to try to close that gap? Or do you think that in the U.S., whatever data sharing happens is just going to be less frequent and perhaps less granular than what the EU ultimately requires.
Yeah, I think this is all to be determined. So the way that the judge wrote the order in the U.S. case was to say that the data needs to be made available to qualified competitors at least twice, but then leaves open for the technical committee to define the exact number and frequency of the disclosures to competitors. So in a way, it's a little bit like setting the floor, perhaps. And if it turns out that the technical committee feels confined by that like actually what the judge meant is that he just wanted it to be twice and that's it, then I think the regime, if and when it comes into place in the US, will be very different from what the European Commission has set out. But, it's extremely early days for the technical committee. They have not made any indication that they've, made progress toward defining this particular piece of their remit. And so I think we're going to have to wait and see what they end up doing with this and whether it starts to look, more like what the European Commission has proposed. I mean, I do think one thing that's notable as these different authorities move forward with somewhat similar obligations is that it is all one company. And so presumably from Google's perspective, like once they set up a mechanism that, makes data available to competitors, certainly I think for the competitors that operate in both jurisdictions and perhaps for Google itself, it might be nice to have a similar mechanism operating in the different jurisdictions. That just, makes it easier for everyone. But we'll have to wait and see what the obligation ends up looking like in the US.
Yeah, it seems like in some instances, Google is all too happy to have one kind of, a worldwide standard. Maybe in some other places, it's maybe to their advantage to make it a little bit more difficult for competitors because if, it's a pain in the neck for Google, but something that is a pain in the neck for Google might be, life and career threatening for somebody who's much smaller because they just don't have the resources. So you talked a bit about the EU DMA, Article 611. Can you walk my audience through what ranking, query, click, and view data actually is? And maybe walk through, why can't DuckDuckGo, I mean, Brave has sort of done this, but why can't a company like DuckDuckGo or another rival create this type of search engine?
Sure. Yeah. So when we talk about this ranking, click, query, and view data, what we're talking about is, the queries that users enter into the search engine through any access point, through the Omnibox in Chrome, through their Android device, through the Google Assistant, or like voice search or circle to search. And then what they get back, traditionally they get back the 10 blue links as we like to call them, but also they get the different widgets and the knowledge panel, videos, all these different kind of vertical search features that appear on the page. The other thing that happens when they enter the query is also there's some query reformulation that happens. So the search engine will rewrite the query in order to produce better results. They get the results back, and then the user interacts with the page. So they click, they might hover, they might click and click back. And that provides like a very rich surface of data for the search engine provider to be able to figure out which results perform the best. So there's a correlation between the amount of this data that you receive based on the size of your user base and the quality of the search engine that you are able to offer. And so with Google as a monopolist or a gatekeeper having upwards of 90% or more of the search queries going to it, it just has like a much, much larger base of data that it can use to optimize its search engine compared to its competitors. I think in the trial in the US, what we learned is that 13 months worth of Google user data, like query and click data, is equivalent to 17 years worth of Bing data. And Bing is the second largest search engine in the US. So users enter about, this was all like in the liability opinion in the US, it's data that's a couple years old, but users enter about 9 times more queries on Google than all of its rivals combined, and 19 times more on mobile. And then the other, I'll just end with another tidbit from the liability opinion. There was an expert who did like an analysis of a data set of like 3 or 4 million unique queries. So, queries that are not repeated anywhere in the data set. And 93% of those queries were only seen by Google, whereas about like 5% of them were only seen by Bing, its closest rival. So you can see from these statistics that just by virtue of having such a dominant position in the market, Google has a much better window into what people are searching for and how to feed them with results that are satisfy what their querying needs are than even their closest competitor.
And the idea here is that if additional companies had access to at least a portion of this data, there would be much more innovation in terms of the search marketplace. A whole bunch of interesting things would spurn up, and we'd start to see innovation in this space. So super cool. But I want to maybe talk a little bit about some of Google's pushback. There was a Wired article that I read where Google is claiming that their red team could re-identify search users in less than 2 hours. They argued that, if data can be re-identified, well, then it's not anonymous in the first place. And so I'm curious, because you have such a tremendous wealth of tech experience, like, what's your response to that type of framing?
Yeah, I think these kind of arguments, to be honest, like, they basically miss the point entirely. I think the interesting thing about this conversation is what the actual risk is to actual users' privacy. Like, the logic of Article 611 in the DMA is that competitors to Google will be paying money, perhaps significant amounts of money, to access this search data set, which is a unique data set. It's, the idea here is that it's very valuable to these competitors because it will help them improve the quality of their product in the market and be able to compete better for users and be able to retain users better. I mean, one thing we didn't talk about just now is that this experience that happens sometimes with the smaller competitors, that like a user switches. I mean, you can choose another search engine by just typing their domain name into your web browser. You try another search engine, and if the first search that you do, the result seems like not that great, it's very easy to switch back and just go back to Google, right? So being able to produce quality responses in the first instance and keep people coming back to you, that's the whole ball game here. And so the point is that these competitors will be purchasing this data in order to make their product better. They will be audited before they ever get to purchase the data. They will be audited 6 months in, and they will be audited yearly if they violate any of the privacy protections that have been stipulated in the contractual measures that the European Commission has put forth in its final measures in this case. And if they get caught, they are in violation of the GDPR and of these contracts that they have with Google. So we have to think about, like, what is the incentive of the competitor to go ahead and try to re-identify a user here and there in this data set, when the consequence is that if they get caught, they're going to lose access to this valuable asset that they paid money for. And then on the flip side, I think, the other thing that's really tricky about this whole debate is that, like, in some, like, all of the industry players have their own bias when they're, debating this in public. And I think when we hear these arguments from Google in particular, that we're supposed to be very afraid of this, we have to think about who that's coming from. It's from Google. It's like the company that takes 90% of our searches, all of our YouTube watch history, our Gmail, our Android data, our Google Maps location information, the data about every website we log into with Google Login, the data from our Nest thermostat and our Google TV. They roll it all into one kind of giant super profile of us. And that's the actor who's telling us we need to be concerned about the possibility that some competitor of theirs might downstream decide to try to re-identify a user here or there, even though that's against their own, business interest. So those kind of arguments, like, I just don't think they hold water.
Well, in New York, there's a term we like to use called chutzpah. And it seems like that that comes to mind when Google's making these arguments. So because there's sort of a broader thing which you're touching on, which is like, it seems like Google is taking the position that the data is really sensitive, that therefore they're the only ones who can possibly use it in a way that is privacy protective. But there's sort of a subcomponent of this where, like, I almost think that if one is going to focus solely on re-identification, I think you need to take into account that in a world that is powered by AI, I don't think that anonymity is even possible. Like, we've all seen studies, going back 10 or 20 years that says, well, if I picked out, 6 data points, I'd be able to identify X percentage of the people. But the problem is that AI is so good at connecting disparate data points that, like, first of all, it's probably only 4 data points. And then the percentage of people you can use to re-identify with just those 4 data points, it has gone exponentially higher. And so I guess that's a long-winded way of asking, like, does anonymity even matter anymore?
That's quite a loaded question. I mean, I think I just bring this back to the incentives of the actors in this space to think about whether all of that work, even to, take these data sets, try to combine them with other data that the competitor has, direct their AI tools at these data sets in order to try to re-identify some likely extremely small number of users in this data set. What are they doing with that? Like, why are they incentivized to do that when the reason they paid for the data was to make the search engine better, right? To be able to deliver better search results, which often has nothing to do with the identity of the user who is searching, right? So I think, we can debate, and I think the whole, formal privacy community debates this a lot about the level of re-identification risk, or, what does it mean to be truly anonymous in a world where we are surveilled all the time and we have very powerful tools to run data analysis all night long while the rest of us are sleeping. But I think that misses the point a little bit when we're thinking about businesses that are trying to vie in the market for share and offer higher quality products, and the kinds of things that they need to do in order to make that happen, which likely doesn't involve these like occasionally being able to re-identify a user here and there.
So I'm a fan of the HIPAA de-identification standard conceptually, and I feel like we've completely upended it in the US because the way that U.S. privacy law at the state level is defining de-identification sort of swallows I don't even know how you really de-identify a data set and bring it outside of the scope of the rule set. And I'm hopeful that, one of the directions that, we as an industry can push things is closer to, and maybe HIPAA isn't exactly right, but conceptually the idea that you've at least removed the risk and you've set up incentives in such a way to reduce the possibility of re-identification. Well, then you've got something you can work with. And I think I'm agreeing with you. I feel like I've asked a question that might have been more apropos for our college days as one passes the skull bong and talk about, well, can one really be anonymous in this jaded world that we're in? And then we'll listen to Ryan Adams or something. But in any event, I want to talk a little bit about some of that tension, because you've got two different browser companies. You've got Brave, certainly holds itself out as privacy protective, and they're calling this proposal a severe privacy risk. And then you've got Camille Bazbaz at DuckDuckGo, who's a friend of the pod and has come out a couple of times, and he's saying that the legal standard only requires reducing risk to an insignificant level, not eliminating it. And so this sort of builds on the previous question, like, how do we make sense of those disparate views? And is it as simple as, well, DuckDuckGo has built their index to a certain extent and doesn't need the data?
You mean, Brave has built their index. Yeah,
Brave,
I think, look, I mean, like I said before, like every player in the market has their own market interest here. And I think that's one thing that makes it tricky to reason about this from a sort of neutral perspective. Like, I work at a university and I'm just like trying to synthesize expertise on this. And so I don't have a product in the market, but they have products in the market. And so I think the way that they feel about these measures to increase data sharing is correlated to what they expect the effects of that data sharing to be in the market. And so if you have invested a good amount of capital in both building your own index, but also, Brave makes use of their users' browsing data in order to try to improve the quality of their own search engine through this web discovery program that they have. That's a different model than DuckDuckGo, which relies mostly on Bing and other search providers through syndication, and potentially could take this data set and use it in different ways. And I think that would be true across the board. Like if you went and asked like 5 or 7 different search engines, what would you do with this data? How would you use it? What would be its, most benefits to you? They would say different things. And if you've put a lot of money into building your own solution and you suddenly see that others might get, a sort of end run around that because they're going to have access to Google's data, then you might think differently about whether you want this proposal to go forward or not. So I think that's just like a way to understand the framing that the different companies are giving this. I think in terms of the actual standard, there's this joint guidance from the European Commission and the European Data Protection Board that specifically speaks to the interaction between the DMA and the GDPR for the purposes of this search data sharing provision. And that's where this standard of like the likelihood of identification being insignificant, or this word insignificant, that's where it comes from, right? So they've put out this guidance saying like that's what the standard needs to be. And what the European Commission says is that the combination of the technical and contractual measures that they've established brings the residual risk of re-identification down to that insignificant level.
Which I think is one of the challenges for the EDPB, is that it's just really difficult following their guidance to really remove a data set outside of the ambit or the orbit of EU data protection law. And because of that, because it's near impossible, or because there's just so many hoops that one needs to run through, it just makes the whole process significantly more difficult. And in some level plays into Google's hands, because they can point to something and say, well, this, the EDPB is saying that this isn't anonymized. So look, we're just relying on the groupthink within the EU regulatory community. And on some level, they're right.
Yeah, that's a good way to put it. And I think that's unfortunate. Like I said, like I wish more of this was about like actual people's actual privacy. It would be nice if that was more of the conversation, instead of like these arcane debates about like what this or that body of the European institutions, which words they use to define anonymity, right?
I was hopeful that the digital omnibus would trigger discussions to maybe rethink some of those concepts. But here we are. The EDPB basically restated the Article 29 Working Party guidance from 2014. And so one of the things that I think doesn't get talked about enough within the context of the digital omnibus, and I apologize, I'm diverting here a little bit, but one of the things that doesn't get enough airtime is that EU data protection regulators are a rather stubborn bunch. And so when the politicians come up with something like, yeah, this is new, this is different, we need to think about it this way, it doesn't strike me that they have the buy-in of the DPAs. And that is ultimately going to undermine this whole process.
Yeah. I mean, I think this is one of the challenges of having this kind of decentralized and disaggregated governance generally. We've seen different models applied here, but at least, in the UK, you have, I can't remember what it's called, but where they got all four of the regulators together to try to like get onto the same page between the competition authority and the ICO and the trade authority, et cetera. And it feels like there's more of that that's needed in the European context.
Completely agree. And I thought that was a really smart move within the UK. You are starting to see some of the competition authorities in Europe take a look, some of the individual member state competition authorities take a look at individual practices that are being held out as privacy protective and look at those via a competition lens. And I think that's also healthy, because I feel like for way too long, those have been discussions happening in completely different, not even different rooms, but different zip codes. And that's just not healthy, given how data driven most of the innovation is right now.
Yeah,
so
I agree.
I want to talk a little bit about the US. We've been kind of forked over into Europe, but you've pushed hard for ongoing evaluation by neutral, independent experts, rather than Google and or its rivals. And you think you've done a great job of framing just that, each entity here is going to have their own viewpoint, and that viewpoint is going to be based, at least in part, on some of their business interests. There's nothing wrong with that. But what does a credible independent assessment look like in practice? And is the U.S. Technical Committee model sufficient? We're a year into the creation of the technical committee. Is there a report card? Because you're probably looking at this a lot more closely than I am, and probably a lot of my listeners are. Like, where are we there with the technical committee? And do you see hope for that being the way to address some of the concerns that we've raised?
Yeah, I love this question, actually, because it helps us think about the institutional design, which tends to be just sort of like a byproduct, but actually ends up being the most important thing sometimes. So I think just to be clear on the EU side, so the Commission had put out proposed measures in this case. At KGI, the institute that I run, we put in comments saying that they needed to have a provision for independent evaluation, like ongoing independent evaluation of these measures, because they're not static. Like, if you even just look at, there's like a provision in there about query length. So, queries over a certain length will get removed from the data set for fear that they are identifying or unique. Like, do you think queries are getting longer? I think queries are probably getting longer because of the chatbots, right? So these are the kinds of things that you need to have ongoing evaluation about. And that was something that we had flagged in our comments. And helpfully, when the commission put out the final measures, they were very clear that, first of all, the measures will be subject to a biennial review that takes into account like practical experience and new developments. And then also that the DMA has a provision that allows the commission to reopen the proceeding any time when there's been a material change or when the facts on the ground have changed. And that's a place where they can kind of measure and test and monitor, including through independent third-party evaluation. So I was really heartened by that, just to see them call that out, that like they're fully acknowledging that there's a pathway already in the DMA to be able to do ongoing monitoring and evaluation and to adjust. You know, my understanding of how that works, how that could work in the EU context is basically through like the retention of independent experts by the commission. And that's actually what they did to create these measures in the first place. They retained an independent expert who helped them to shape these measures. So that's sort of the way that they can do that in the European Union. In the United States, we have obviously a completely different regime, and this is a technical committee that's been created at the order of the court. Again, they are early days. They are still like fighting about, I think, like non-disclosure agreements and compensation. And, they're still in bootstrapping phase, essentially, the technical committee. But I do think the expectation is that they will be able to retain, beyond the 5 members of the committee, that they will be able to retain consultants and contractors who have different kinds of expertise. We, together with some other experts, wrote a sort of blueprint for how to make the technical committee most effective. And if you look across all of the responsibilities that technical committee has, which we sort of ticked through in that blueprint, they're extremely varied. Like there's no way that these 5 people have the expertise that the technical committee needs in order to complete all of its function, nor would any group of 5 people have them because of the breadth of the responsibilities. And so they should be able to retain independent experts, people with formal privacy, training and expertise, et cetera, to be able to help them sort through these kinds of details as they're looking at the data sharing provision specifically.
That makes sense. And are you bullish on how the technical committee is working, or is it still a little too early days to feel confident or not?
Yeah, I think the picture is a little cloudy right now. Again, as I said, like the only window that we have is these like status reports that they file with the court. And I guess you can also like call into the status conferences, which I have not done. So full disclosure, I might be missing some of the details, but yeah, they appear to be sort of tussling around still some of the organizational issues and getting the technical committee set up. And as a result, I think some of their initial deliverables, they have, requested and received extensions in order to produce some of the items that they were meant to start with. The other thing is that there's an appeal and there's a cross appeal in that case that are ongoing. So, the briefs are sort of flowing in over this summer, and the appeal will be heard sometime probably next year, I guess. So all of that means that there's some murkiness around the technical committee actually being able to do its real work. And that will, we'll see how that continues to clear up as they sort through all of these like bootstrapping issues.
Well, I really appreciate you coming on, Alissa. This has been a fantastic discussion, and just grateful that you're willing to come on and share some of your insights. I've got one more question for you, and it's a little bit more of a crystal ball type of a question. Do you have a sense or a prediction of how all of this plays out? I mean, what does it look like if Google, just runs the clock for the next 5 years, and pricing disputes and audit friction, and nobody can really prove noncompliance? I mean, do you think that's the most likely outcome? Because in my view, Google's so good at playing these games that anybody trying to come into this is sort of up against that. But as somebody who's looking at this a little bit more closely than I am, perhaps, do you have a reason to be optimistic? How do you think this really plays out?
Yeah, so I think if we look at the DMA and the measures that have been put in place, one helpful construct in there is that there's no single clock running. I mean, as long as Google remains designated as a gatekeeper under the DMA, they will be subject to the obligations under Article 611 for search data sharing. The clock actually is a per competitor clock. So once any given competitor gets access in the first instance, then they retain access. That competitor retains access for 5 years. So I think that's actually like a super interesting model, because it means that there's not like a single sort of timeline that Google can, try to stall out through appeals and friction and so on. That's on a competitor by competitor basis. I think from the legal perspective, next open question is whether Google will challenge the final measures that the commission has put in place in court. And, obviously there will be some delay associated with that. And we should know that, I think, like by the end of September, just given how EU law works. So I think we'll see there might be a little bit more churn around that. I mean, it's basically in all of the gatekeepers' interests to challenge everything that the European Commission does. When you look at how much it costs them versus how much, Google's a $400 billion revenue per year company, it's certainly well within their means to challenge every single one of these and take it to the mat. And so it's not surprising that that happens, but we have to wait and see whether it will. I think once the framework comes into place, yeah, fully agree. There's going to be friction around, I think, a number of different points. Who's eligible? Like there's now a lot of criteria that are established in order to make sure that these are legitimate competitors, that they have a big enough footprint in the EU, that they're not controlled by a third country that has cybersecurity vulnerabilities. There's like all kinds of criteria in there now. So there's lots of surface area to try to exploit.
So all U.S. companies are ruled out?
I mean, it's TBD, right? Like it's written in a way that's generic enough that you could have an argument about any company from any country. And we will have those arguments, like there's no doubt, right? So introducing friction at each of these points is just part of the gatekeeper playbook. It's in their interest, and that's what they do. So yeah, I think eligibility, as you said, pricing of the data, and then like the scope of the data. Like at the end of the day, if a competitor does succeed in obtaining this data, like will it actually meet the requirements that the commission has laid out, or will they continue to argue back and forth about that? So I think this is just like, this kind of friction is just in the nature of these things. Like nobody of this size and market power just complies willingly and sort of, gives up the game. And so that's just the adversarial setting that we need to be prepared for going forward with any of these regimes. Will be the same in the US with the technical committee as it is in the EU. And I think the important piece is to put these kind of governance frameworks in place such that the authorities making these decisions, the European Commission, the technical committee, whoever, is able to ground their decision making in solid evidence. And also just, put in the plea to have some independent evidence and independent expertise part of that conversation as well.
So is your sense that there's a chance, at least, that over the next 6 to 12 months, we get out of the preliminary phase and things really start to happen? Like, is 2027 going to be a particularly interesting year as we look at this? Or is that still TBD because we haven't really opened the floodgates yet?
I think it's still TBD. Again, I'm not a lawyer and I'm definitely not a European lawyer. Like my sense is, if I'm thinking back to there's been a few challenges to different aspects of the DMA already. Apple and Meta and ByteDance, they all challenged their like original designations under the DMA. And, there's recently a big decision in the EU General Court about that vis-a-vis Apple. But that means that even that case is not concluded. And that's been like 2 years. So I think if Google does challenge this, my spidey sense is that it might not be concluded in 2027. But again, I'm not that read in on the details. But I assume that once we get into litigation, things take a while.
Well, thank you very much for coming on, Alissa. This has been a fantastic discussion. Where can people find you?
You can find us at kgi.georgetown.edu. And I am Alissa.Cooper at georgetown.edu. You can also find us on LinkedIn and Blue Sky. Happy to engage with anyone anytime on these topics. There's not enough of us diving into the whole competition and privacy melee.
Completely agree. But it's fun discussions. And so I'm so glad to have you on. Hopefully you come back.
Absolutely. Thanks for having me.
Okay, that was a great discussion with Alissa Cooper. A few things I want to share. First, let's talk risk. A few times, Alissa redirected the conversation back to a deceptively simple question. What's the actual risk to actual people? And that's a great point. Alissa pointed us to a few key considerations in connection with the third parties that would be obtaining search data from Google. The companies who are looking to receive this search data would be paying real money for it. They'd be audited before they get it, audited again 6 months in, audited every year after that. And if they even try to re-identify a user, those companies would be in breach of both their contract with Google and the GDPR, which means they lose access to the very asset that they just paid for. So ask yourself, what is the incentive for those companies to cheat? When you frame it around incentives rather than theoretical capability, Google's position where, well, the data could be re-identified, well, that starts to look less compelling. But this is also a great example of what I noted in the intro about making different arguments in different venues. Here's what I mean. Historically, it's been the ad industry, including Google, that attempts to tie risks to actual tangible harms in public policy discussions. Conversely, it's been the advocates, including some of Alissa's former colleagues at the CDT, that were arguing that ethereal harms are worth preventing as they talk about the risks of data sharing. I'm sure there is a Freaky Friday joke in there somewhere. And that brings me to my second point, the part Alissa and I didn't get to. Now, I've been focusing a good deal on privacy-enhancing technologies in the ad space lately. We just had Martin Thompson of Mozilla on the pod to talk about the W3C attribution spec and other pets. Well, these pets play directly into some of the inconsistencies we've been discussing on the pod. In the ad space, pets include differential privacy, federated learning, secure aggregation, techniques designed to let you extract useful signal from data while making it mathematically hard to tie any record back to a specific person. Now, Google is one of the most sophisticated deployers of pets on the planet. It built differential privacy into Chrome years ago. Google championed the privacy sandbox in advertising, and its entire pitch there was that federated, aggregated, noise-injected technologies let you do things that are useful with data in a privacy-safe way. Google publishes research on this. It markets the tools as proof that you can have utility and privacy at the same time. So when Google wants to process sensitive data for its own purposes, ad measurement, on-device intelligence, analytics, Google's public position is, don't worry, the technology handles it. So here's the question I'd love to put to a Google spokesperson if one were sitting across from me here. If pets are good enough to protect users when Google is the beneficiary, why are they suddenly inadequate the moment the beneficiary is a competitor? You can't have it both ways. Either these technologies work, in which case the search data sharing regime can be built on top of them, or they don't work, in which case a lot of Google's own privacy marketing efforts deserve a second look. Google's Heather Adkins told Wired that the working assumption is that once data leaves Google servers, we lose control of it. But that's precisely the problem pets are designed to solve. Done properly, the protection travels with the data. So in that light, the we'd lose control at the border argument only holds if you assume the technology Google itself has spent a decade promoting doesn't actually do what Google says it does. I'm sure that my friends at Google will text me privately with clarifications, but hear this. Pets don't operate by magic or by Google's whims. And that leads me to a third point, one Alissa and I touched on but didn't fully unpack. The role of EU DPAs and the European Data Protection Board in all of this. The whole search data sharing regime in Europe hangs on a single word in Article 611. The search data shared must be anonymized. Anonymization is difficult enough to define, and respectfully, the EDPB definition sets the bar so high that if you adopt the EDPB standard, it all but ensures that nothing useful actually gets shared by Google. And as Alissa puts it, that plays directly into Google's hands. Google doesn't have to win the anonymization argument on the merits. It just has to point at the EDPB and say, look, they're the ones who set an almost impossibly high bar. We're just following it. In that way, the anonymization standard becomes the leverage point. And in case you think I'm just picking on Europe, I'll note that the US state privacy laws have effectively blown up the HIPAA de-identification standard. And all of that is before we start talking about AI's ability to connect different data sets to draw inferences and enhance identifiability. There is a paradox in play here. The more powerful AI gets at re-identification, the smaller the data set it can crack until anonymous becomes a category that just can't exist. And if nothing can ever truly be anonymized, then a legal standard built on anonymization can't ever be satisfied. The tool we built to protect privacy quietly makes the legal test impossible to pass. I refer to that as AI's omnipotence paradox. So, Here's the seam I can't get past. No competition remedy that involves data sharing is going to work smoothly until the privacy regulators and the competition regulators are actually in the same room. The UK, to their credit, at least tried this, getting the CMA, the ICO, and others around one table. Brussels has not cracked that yet, and until it does, the definition of the word anonymous is going to keep getting in the way. And Alyssa's closing plea is the right one. Whether it is the Commission in Brussels or the Technical Committee in DC, these decisions need to be grounded in independent evidence and independent expertise. Not Google's evidence, and not Google's search rivals' evidence either. Neutral evidence, evaluated on an ongoing basis because user behavior isn't static and the AI features reshaping how we all search aren't either. If you want to go deeper, the Knight Georgetown Institute's comments to the EU Commission are worth your time, as is Dirk Auer's piece in The Truth on the Market. We didn't get into Dirk's article, but it's another great example of a regulatory seam, and I'll include it in the show notes. I'm Alan Chapell. This has been the Monopoly Report. We have a bunch of other fantastic guests coming up in the next few weeks. Please subscribe to the show at monopoly-report.com or on Spotify, Apple, YouTube, or wherever you listen to your podcasts. And thanks for listening.